So to that event, what I am going to do is I'm going to initiate the following, and I'm going to put it in administrative order. And here's what I'm going to do. On Mondays, Thursdays, and Fridays, we're going to start at 8:45 and reclaim a little bit of time. So if you need to take up anything, we'll go ahead and take it up before a jury gets here. That's number one. There's 5 things I'm going to implement. 2 is going to be the exclusion of any evidence, documents, or pictures that aren't timely disclosed. So, defense, if you argue that they haven't been timely disclosed, it will be the state will have to tell me what date and did you disclose that particular evidence or discovery in the same or substantial format that it was given to the defense. So, because what I'm having is I'm getting, well, the state changes it or expands it or just comes into possession of it. So if it hadn't been disclosed already, you tell me, for example, we gave that to the defense on April the 15th of 2023. And you can show me that it has been in fact filed that day, then we'll proceed. If not, I have remedies. The remedy, I'll exclude it, or I'm going to excuse the jurors on the spot, and they're gonna come back the next day, and we're gonna work to resolve that. But I'm not gonna have them sitting here every day, and then they're gonna, of course, make certain judgments for themselves. I'm not gonna say anything, but I told you that the biggest thing that jurors complain about is having to sit back there. Also, if it's so number 2 is I'm going to start excluding stuff that if it's changed from discovery, hasn't been disclosed in discovery, or I'm going to reserve the right to go ahead and exercise that remedy at that point in time. So, defense, if you're going to make that argument, you need to be able to tell me what's changed about the particular evidence, if so, because after the state tells me, okay, well, we gave it to you on the 23rd, well, then you have to be able to tell me, here's what else they gave me. So I may just exclude that portion of it. So I'm going to start just excluding stuff in that respect because it's not timely. But whoever the proponent of the evidence or asked for the exclusion is going to have to tell me, well, when did you disclose it, and in what form did you disclose it? So, because this is why I've told you all, get together earlier, talk to one another, and if you have problems, then certainly or issues I need to resolve, file a motion. Let me know so I can go ahead and take it up. But I'm hearing about it a lot of times the first time when the jury sits in the box. And I can't do that. It's not fair to them, not fair to me as your trial judge to be able to rule on those kind of things. So related, number 3 is I'm going to start, if appropriate, and I do need to take up something that is of that important or import, I will go ahead and excuse our jurors. And just we'll take whatever, and we'll come back the next day. So that's 3. Number 4 is I have spoken with our sheriff, and consistent with court, if necessary need be, we'll start having court on Saturday and Sunday. Yeah, well, that's my call. So if you don't want your Saturday and Sunday sucked up, I think we need to work a little harder in terms of being able to streamline, and that goes to both sides. And look, I don't want to work that way too, because it's me and my staff and my team and the sheriff and his team and everything else. But we will do it because we're going to have to recap some days. I don't want to be in 2027 trying this case. Or as Mr. Steele said, I want to be here next Super Bowl trying this case. I'd like to have it. I'd like to be able to watch the Super Bowl without having to come back to try your case. I hope that your case is resolved by that time, whatever may happen. But I think that we can do a better job at presenting the evidence and streamlining whatever for the fact finder to be able to make a decision. So we're going to start gathering on Saturday and Sunday. And the last remedy, and I don't say this being otherwise mean and contrary and everything else, but I have, I have power of contempt. I don't want to use that. I don't. But it's come down, we've been in trial a long time. I think I've been very clear with everybody about my expectations, which serve you all and your ability as advocates in this case to try the best case you have. So that's why I said I wasn't going to kind of let you all start pointing fingers at each other, because I think there's enough blame to go around. But you all are going to have to, as I've said before, do better. You all are very seasoned advocates. So I shouldn't be having these many discussions and interruptions. I mean, and I'm in no way saying you're not doing your jobs, because that's what you're paid to do. You are doing your jobs. But the challenge to the court is that we've had a lot of interruptions with the jury sitting in a box. And I told you my concerns about that. So that's where I'm going to draw a line. And I've thought long and hard after these motions. I was thinking about this prior to Mr. Weinstein filing his motions and his supplemental motions to limit the witnesses. But I have to do something that will at least make us or force us to go ahead and make sure that we can present a case to the jury that is more streamlined and not stops and starts. I mean, if we get 2 or 3 hours a day, we're doing good, because we had so much interruption. And a lot of that interruption was needless. It could have been taken up much earlier. So, so that's where I am at this point in time.